Hi guys and gals, we're finally going to get into our part 3 version of our Fourth Amendment series, okay, regarding criminal procedure, okay? So if you're a Crim Pro, listen to every single thing I say because literally every small detail on this board and what I'm going to tell you will be on your final exam and also the bar exam, okay? So let's finally understand exactly what it takes for an officer to have probable cause, reasonable suspicion to stop and frisk you, to arrest you, search you, and seize you, and even have probable cause based on hearsay, which is when another person, a third person, tells the officer certain information about what you did for the officer to have probable cause to actually search you, arrest you, and seize you, okay? So let's get into what probable cause means. And then, as I said, after this video for part 4, we're going to get into the top 6 exceptions that are most tested and most frequent when it comes down to criminal cases such as this, okay? So let's get into PC. I like to call PC probable cause. As you can see right here, PC, all right? So we have 4 very short and sweet sentences that I like to focus on in order to understand exactly what it takes for a police officer to have probable cause that you specifically committed the crime, and these are the facts that makes an officer have probable cause to say, okay, look, this particular person committed a crime, therefore, let me search and seize this person, let me arrest this person, and let's see what happens from here. This person could be culpable of a crime, okay? So let's go through A. A says, basically the officer must have a less than more likely than not that the person committed the crime, and I have actual facts that the person committed the crime. However, but it must be more than a bare suspicion. So the cop can just simply suspect you of committing a crime, okay? He must have actual facts, okay? And what does that actually mean? If I want to be more specific, what does that mean? That's what we're going to get into letter B right here, okay? Letter B states that the officer's facts for wanting to, arrest you, pull you over, whatever, must be based on objective and articulable facts and circumstances that will make the officer say, okay, I have more than a bare suspicion, but I'm not quite sure 100% that this person committed a crime. But I have these facts that make me believe that this person committed the crime. Therefore, I'm going to put my lights on and pull this person over and see what's going on. Or, as I said, stop and frisk, arrest you, whatever. And we're gonna get into those specific examples right after I explain C and D. Okay. So C stands for the officer must point to specific facts to support the reasonable inference that the person committed the crime. Okay. So as I said, the officer can't just have a suspicion and I think that person committed the crime. The officer can't do that, okay? The only way for an officer to have actual PC, probable cause, is when the officer can point to precise and specific facts that support his or her reasonable inference that the person actually committed the crime, right? Example, if you're walking around and you stink like weed and you're in a state where weed's illegal, and the officer happens to see your eyes red, high as the sky, those are articulable facts that can give the officer reasonable inference and also specific facts to back up that inference that say, okay, look, this guy's eyes is bloodshot red, he stinks like weed, okay? In this state, let's say Minnesota, weed's illegal, therefore I have probable cause that this person could be up to no good. Probable cause to arrest, search, seize, and even stop and frisk. Okay? So let's finally get into D. The officer needs to be particularized in exactly what those facts are. So the reason why it's saying, again, articulable facts and circumstances, specific facts, particularized, is because the officer must really have very specific reasons about why he or she believes that this specific person committed the crime, or the officer must have specific facts about why the officer believes that a crime has occurred in a certain place, right? So let's say that the officer thinks that this drug lord is hustling drugs in his home. Okay, so let's say the officer has probable cause that the person who's a drug lord is like selling those drugs, right? The moment he has probable cause and he has those articulable and specific facts that's actually happened, and they're also particularized that that's happened, that's when the officer could possibly get a search warrant from a judge and search that person's home to find out what the hell's going on. Okay? So we're going to get into actual examples. We're going to get the case law. As I said, the Fourth Amendment is very heavy in case law, but using those examples to help us understand what happened to other people and help us understand exactly what it takes to get arrested, the probable cause, etc. Okay? So we're going to transition into a case right now. Okay, so let's finally get into a classic case where you get pulled over by the cops. Okay? You get pulled over by the cops, whether it's soon or whenever. Listen to this, because this is pretty interesting on what happened to this defendant, okay? Luckily, in the end, his case got dismissed for a good reason, which we're going to talk about right now, okay? So the facts of the case is very simple. I put 3 sentences here out of the long paragraphs that you would read if you actually saw the case online or in your textbook, okay? So, make it short and sweet. Fact number 1. Police officers stopped the defendant due to a traffic violation. The defendant was driving and he got pulled over. Okay? Simple so far. Again, traffic violation. Therefore, the police officers do have a reasonable suspicion that a crime has been committed. Therefore, they have articulable facts and a reasonable inference that they can turn to say, okay, we suspect that this person is committing a crime, right? So, check 1 for fact number 1. Let's get to fact number 2. The fact number 2 states that the driver was actually the defendant's brother. Okay, so the person driving the car was the defendant's brother, but the defendant was still in the car though. There were 6 people in the car, okay, including the defendant, as I said, but his brother is the one driving the car. And the driver gave the officer consent to search the car, okay? As you can see up here, it's the classic consent case. This is for those who do not know their rights, because in this case, he did not have to give the cop consent to search the car, because the only time an officer can actually search your car is if the officer has probable cause, okay? But in this case, it was only a simple traffic violation, okay? So the officer had a reasonable suspicion, like as I said, facts and a reasonable inference to turn to that, hey, this person committed a traffic violation, okay? No other crime but a traffic violation, okay? So the cop wants to search your car. The cop must have probable cause, which is a higher standard than reasonable suspicion, okay? And the only way that a cop can actually do that is if they have probable cause that you're actually committing another crime, okay? So let's say a car stinks like marijuana, or they see a crack pipe in your car. That's an example of course, of course the cop can search your car because there's clear evidence right there that there's a crime committed, okay? And as I said, I'm referring to states where marijuana is illegal, okay? So let's go to fact number 3. Fact number 3 is that in this situation with the defendant, police discover stolen checks, okay? So this guy was up to no good, but because he did not know that he could refuse the officer to search his car, this evidence was suppressed, okay? And the holding boils down to this. The Supreme Court held that the defendant did not need to give consent, nor did the defendant really know his Fourth Amendment rights. So because he was ignorant to his own Fourth Amendment rights, and because the officer didn't have the right to search his car, and because the defendant did not have to give the cop consent, it was optional, it was voluntary, okay? I'm guessing he was probably scared of the police officer, that's my guess, about why he consented, although he didn't have to consent. Plus, as I said, he didn't know his Fourth Amendment rights. So if you don't know your rights, and if you also don't know that you can tell the cop, no, you're not searching my car, I guess this could happen to you. Fair enough. And lastly, the case was dismissed. And it was dismissed based off the fact that, as I said, the defendant did not know his Fourth Amendment rights, and the defendant did not know that he could tell the officer, no, you do not have the right to search my car because I'm not giving you actual consent. Okay, so basically consent must be voluntary, must be a thing where the person knows their rights, and even though they know their rights, they are giving the cop voluntary and intentional consent to say, hey, you can look through my car. Fine. Search my car. Get the dogs to be dogs, whatever. You can search my car. Here's some permission. Here's my consent. But because this person did not know that A, he could say no, and also B, he didn't even know about his rights, that's a big reason why the cop found the stolen checks and was able to search his car. And that was a big reason why when it finally went to trial, the Supreme Court, SCOTUS, dismissed the case based off these reasons. So let's get into one more case, and it should be pretty straightforward and understandable about what you should and should not do when a cop comes to your car or simply comes up to you face to face in person. Okay, we're gonna finally get into the last case that talks about getting stopped and frisked by the police. Okay, let's say you're walking around and then the cop comes up to you and says, "Oh, stop, wait." Then he pats you down. We're gonna go through that. Okay, there's a certain standard that the officers must have before they can even touch you, before they can even stop you. The list goes on. And the case that we're going to talk about, Terry versus Idaho, is the classic case that will explain what I'm talking about. And you can keep this in mind for whenever this may happen to you. Hopefully it doesn't. So, that's how I'm talking about Terry versus Idaho. This is the classic case of getting stopped and frisked. It's called Terry stops. Okay? So let's get into 3 simple facts that I wrote down in order to compress all the facts of the case into 3 simple facts. Fact number 1, the defendant, Terry, and the co-defendant were walking back and forth in the street while peering into a store. Okay? Let me explain this a little better. So basically, him and his buddy are looking into a store. Okay, let's say you are the store. I'm Terry, and pretend that I have the co-defendant right here. We're walking back and forth, peering into the store, looking into the store, back and forth. That's what he was doing. Fact number 2, the police officer then had reasonable suspicion, I said RS here, reasonable suspicion that they were up to no good, that they were casing, this is basically slang for wanting to check out the store so they can see whether or not they can rob the store, okay? He had a reasonable suspicion that they were doing that because I think it's pretty clear that, come on, if you're walking back and forth and you're peering into the store like this with your buddy, you know, that will give an officer, basically a reasonable, prudent person in the officer's position that, hey, well, there's some criminal activity happening here. I have some pretty good facts, articulable facts, that can have a reasonable inference that, hey, these guys are up to no good, okay? So, again, they're casing the store, and then he stopped them, okay? And the only time that a cop can stop you is if he has reasonable suspicion, okay? If the cop doesn't have this, if the cop can't tell you why he's stopping you, walk away. Just walk away. Come on, please walk away. Don't be scared. Just walk away. He can't do that. He can't just stop you for the heck of it, okay? He must have some facts and a reasonable inference about why he's going to stop you and think that you're up to no good. Criminal activity, right? So, again, this is the standard under the law. Reasonable suspicion. If this is not the case, an officer cannot stop you, okay? So lastly, fact number 3, the police officer frisked. What does that word mean? Police officer frisked them and found guns. Frisking is when the officer stops you, then he says, hands above your head. Then he starts searching you, patting you down, searching in your pockets, all right? That's an example of frisking you. It's basically a pat down, okay? So once the pat down happened, again, the frisking happened, he found guns. And he felt guns. You know that little bump that you would have in your pocket or your big jacket? You know, if you basically pat someone down, you can feel that bump. You can feel the feeling of a gun in there, right? It's like you can feel the big square in your pocket when you have your cell phone. That's what the cop did to the defendant here. So he stopped them and he found guns, and basically they were culpable for attempted robbery. And as I said down here, this is very critical. The standard is that there must be reasonable suspicion. RS, the police officer must have reasonable suspicion. Like I said, articulable facts that can give the officer reasonable inference that, hey, this person might be up to no good. It's a little less than probable cause. Okay, probable cause is a higher standard than reasonable suspicion, because once you have a reasonable suspicion, like I said, the facts, that person committed the crime, and then you found out that, hey, this guy has guns, right? And he's peering back and forth into the store, right? Then that will rise to probable cause, the higher standard, and then you can get arrested, okay? So again, reasonable suspicion to stop the defendant, that the defendant is going to commit a crime or is going to commit a crime. And lastly, you can get frisk when the defendant is armed or dangerous. Okay, as I said, it could be a gun, it could be a knife, it could be a BB gun. Believe it or not, it could be a BB gun. Okay, as long as you're somewhat of a threat, you're dangerous, you're armed, that will constitute stopping and frisking you. Okay, so I guess the main thing to take away here is that if the officer does not have probable cause, he can't search your car. Okay, if he can't explain to you why he wants to search your car, you just got a simple traffic ticket, or you're loitering, or you're jaywalking, he can't search you. He needs probable cause to actually search your person, to search your car, and he needs a search warrant from the judge in order to search your home. Okay, so a cop can't just come up to your house and say, I think there's a crime here, I'm coming in. Can't do that. Okay. Furthermore, remember, you must have actual consent. Okay. So once you know your rights and you consent to the officer to say, hey, okay, you can look at my car, you relinquished all your rights. And if they find contraband, stolen checks, like our other guy here, you're going to jail. You might be culpable for a crime. Okay. And let's face facts. I don't think anyone wants to be searched, and it's just uncomfortable. Okay. Furthermore, this to wrap this case up, Terry versus Idaho, getting Terry stopped is a scenario where, like I said, the police officer needs to have reasonable suspicion to actually stop you. Okay, an officer can't come up to you because of whatever reason. Okay, even the officer's trying to ask you for directions. I say be nice and give the officer directions, but even that, you don't have to do that. Walk away. Okay. So I hope this helps. Like it, comment, whatever. Let me know your thoughts. And there's many more to come. Thank you.